Right, if somebody I've just admitted, I'm going to, oh, there you go. Sir, can I ask what your name is?
Mr. Perkins.
All right, Mr. Perkins, hold on one second. I'm going to change your screen name, and then I am going to put the initials of your attorney after it. And that way, Mr. Valero, when he's done next door with the other judge, I will be able to remember you're his and bring you back in. So I've changed your screen name. I'm going to pop you in the waiting room, and hopefully it'll just be a few minutes, okay?
Okay.
Thank you. Hi, Mr. Stevenson.
Hello, man. Doing.
Right, if somebody I've just admitted on a Samsung device and I'm sending a request to start your audio.
Yes.
Hi, what is your name, please?
Lindsay Bloomhart.
All right. Change your screen name. And I'm going to put Mr. Murphy's initials after your name. And I'm going to pop you in the waiting room, and I'll be back with you in just a minute, okay?
Okay.
Thank you. All right, I just admitted someone on an iPhone. Sir, what is your name?
Amir Norman.
All right, so there you are. So, Mr. Norman, your attorney is next door. And when she is done there, she will come back in here, and then I will bring you back in, and it's Miss Underwood. So I've changed your screen name and put her initials after your name. So when she gets here, I'll bring you back in, okay, Mr. Norman?
Okay, thank you.
You're welcome. I'll pop you back in the waiting room.
Good morning.
Good morning. Do you have Michael Robinson today?
He is being escorted up. He was in our segregation wing, so give me a few
Excellent.
minutes.
Not a problem.
Thank you.
I'm going to change the screen name just so I know it's him, and when he gets here, I will try to take his case as soon as possible, all right?
Thank you.
Thank you. All right, Mr. Murphy, where you at? I do have Lindsay Blumhart.
Morning, Your Honor. Could I speak with her in the breakout?
Okay. So this is in the matter of the people of the state of Michigan versus Lindsay Ray Blumhart, file number 24-21978FH. This is the date and time set for sentencing in this matter. It is a misdemeanor sentencing. So Mr. Murphy has requested a breakout room, and I am going to open up that breakout room for Mr. Murphy.
Thank you, Your Honor.
Yep, and Ms. Blumhart, when you get the invitation to join it, go ahead and join it. If you can't figure out how to get out, don't worry, I'll bring you out of it. So there you go, join that breakout room with your attorney. Mr. Malaro, I have Lesean Perkins, so I can get started with you, and I'll call the jail to get all your people lined up.
Okay.
All right, so I'm gonna call the jail. It's Gorton. You just have Gorton in jail. Hi, this is Judge Anslone. I was just calling to say I'm ready for Charles Gorton.
Did you say Gorton?
Yes, Charles Gorton, T-O-N.
Yes, ma'am. I'll gather him now.
Okay, thank you.
You're welcome. Bye.
Bye. Okay, so, I have, let's see.
Sorry.
And I have Miss Edmonds too, Mr. Malone.
Yeah, okay.
Are you ready? I'm Mr. Perkins.
Judge, I tried talking to him yesterday about his PSI. If he got it, has no objection, I'm ready.
Okay. All right, Mr. Perkins, hold on one second. So this is in the matter of the people of the state of Michigan versus Lesean Perkins. File number 24-21758FH. Mr. Perkins is represented by Mr. Malaro, who is present here today. Mr. Perkins, did you receive in the mail a copy of the pre-sentence report?
No.
No? Okay. Do you want to use the podium in the hallway? I don't see your laptop.
He's got it.
Oh, do you want to go in the back? It's so little. Oh, you got an iPad now.
It's something, I'm not sure.
All right.
The
So
camera
Mr.
works.
Did you already talk to Christina Edmonds?
I have not.
Okay.
Oh, I'm sorry, yes, I did.
Do you want to take care of Miss Edmonds
Sure.
first? All
I
right.
did.
So Mr. Perkins, bear with us for 1 minute. We're going to take care of somebody else, and then I'm going to put you and Mr. Malaro in a breakout room, all right?
Yes, ma'am.
Okay.
He is really garbled up, just so you know.
I can't hear you. What?
He's very garbled up, just so you know.
All right. Miss Edmonds, if you want to go ahead and unmute your device.
All right. Can you hear me?
Yes, I can. Can you hear me?
Yes.
Okay, good. This is in the matter of the people of the state of Michigan versus Christina Mia Edmonds, file number 24-21983FH. This is date and time. So Miss Edmonds, you're gonna have to like park the car or stay still so that we're not.
Turn that off. Can you hear me now?
I can. Do you need to do something before we can start?
No, I got it now.
Okay. So, and this is file number 24-21983FH. I have Salvatore Malaro appearing on behalf of Miss Edmonds. Darren Coast, our pretrial services coordinator, has provided a letter dated April 29th of 25 that said Miss Edmonds continues to drug test twice a week at a drug testing facility. She does not miss. She is only positive for THC and sometimes alcohol. She has her medical marijuana card and she does not have a no alcohol clause. She has been in compliance with her testing and does well. So, Miss Edmonds, did you get an opportunity to read and review the pre-sentence report?
Yes, I have.
Good. And have you had an opportunity to discuss that with your attorney?
Yes.
Are you satisfied with your attorney and the advice that he has given you?
Okay.
Yes.
His attorney shows up on Monday.
Can you say that again for me, Miss Edmonds?
Yes.
Good. All right. Mr. Malaro, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor.
Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect? I show 4 prior felonies and 13 prior misdemeanors.
Correct. We have no objection to those convictions.
All right. The probation department has calculated the guidelines to be 0 to 11 months. Do you agree with that
I
calculation?
have no
guideline?
objection to those calculations.
You do?
I have no objection.
Oh, okay. Before the court passes sentence, is there anything you'd like to say on behalf of your client?
Yeah, yes, Judge, when I first obtained Miss Edmonds as a client, she was clearly in the throes of her addiction. Unfortunately, she was able to go into a rehab facility. Her total demeanor, behavior changed completely. She's been actually a pretty, like, almost a model client since she did rehab. She's certainly knows how to advocate for herself, which is always important. But she's always, as the courts noted, I think she's been compliant with her bond conditions. I think the recommendation is appropriate, Your Honor. We'd ask the court to follow with one request, and that is with respect to item 16 on page 2, that she have no contact with Sierra Gibson. Sierra Gibson is her daughter-in-law, and she would ask that as long as Ms. Gibson has no objection that be condition be removed.
All right. So what I can do is leave that to be addressed through Ms. Walsh if Ms. Gibson provides something.
Okay, that'd be
Okay.
fine. Thank you, Judge.
Okay. All right. Ms. Edmonds, is there anything you want to say on your own behalf?
I just, I'm sorry for my actions at that time, and I just need another chance to keep my life on track, and that's about it.
Well, thank you, Ms. Edmonds. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criterion reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, potential for reformation, vindication for the law and protection of society. Ms. Edmonds, I am so pleased with your recovery and how well you are doing. You and I are similar in age, and our bodies just don't take the abuse that we give them or used to give them. So I'm so glad that you've kind of made a turnaround on this, and I wish you the best of luck on that. It sends the court, you'll be placed on probation for 24 months. During that term of probation, you can't violate any criminal laws, can't leave the state without consent of the court. I'm not going to add an alcohol clause, but understand if it becomes an issue, I will add that later, okay? You cannot use any illegal controlled substances. You'll be required to drug test, use prescription drugs only as prescribed, attend any AA, NA, or recovery meetings if they're required, complete an outpatient or substance abuse treatment program when referred. If you've already had an assessment, you can provide that to the probation department, but otherwise you might need to do a substance abuse assessment, report as required. Notify the probation officer immediately if any change of address or employment status. We're going to give you a curfew of 11 p.m. to 6 a.m. unless you have work or something else, and you can get approval for that through the probation department. I'm going to put in that there's no contact with Sierra Gibson until such time as Ms. Gibson contacts the probation department regarding that, because I'm not sure why. You must obey all court orders not to engage in any assaultive, abusive, threatening, or intimidating behavior. Not use any object as a weapon. You'll have to report to probation next Tuesday, I'm assuming. Would she report?
Yes.
Okay, so next Tuesday, you're gonna need to report to Ms. Walsh. Is it Ms. Walsh? Yeah. Between 8 and 10 in the morning. And obviously, and you must obey and comply with all of the other articles of probation. There is a $130 crime victim assessment fee, $30 per month supervision fee, unless we have to put a tether on you, which is $60 per month. There's $750 in court costs, $110 OUIL, OUID reimbursement fee, $60 DNA fee, $68 in state costs, and a prosecutor's fee in the amount of $100. They'll set that up in a monthly payment you have to make over the 24 months. Ms. Edmonds, you do, and I'll give you credit, I'm not going to order any jail term, but obviously you get credit for the 56 days you've already served. Ms. Edmonds, you do have the right to appeal this sentence, and we're going to mail to you your notice of right to appellate review. So you're going to receive an envelope that has 3 copies of your notice of right to appellate review and a self-addressed envelope in it. They're going to be something on there to mark one of them where you initial and date it to acknowledge you received it, fold it up, put it back in that envelope that we provided for you, put it in your mailbox and send it back to us so we know that you received it. The other copies are for you. If you wish to appeal your sentence, you would fill them out and mail them to the address listed on the form within 42 days. All right?
Yes.
All right, Ms. Edmonds, I wish you the best of luck. Thank you.
Thank you.
Hey, Christina, you're no longer required to test under grain, so you're going to be testing under your probation officer, okay?
All right.
Sam,
Thank
have
you.
been in court?
Yeah, we're,
I got them right there.
oh, yeah, we're.
All right. All right, you're all set, Ms. Edmonds. Have a good day.
You too. Bye-bye.
All right, Mr. Gorton, can you hear me?
Yes, ma'am.
Okay, I just can't see your face. All right, this is, oh, there you are. This is in the matter of the people of the state of Michigan versus Charles James Gorton. This is file number 24-21934FH. I have Salvatore Malaro appearing on behalf of Mr. Gorton. This is the date and time set for sentencing in this matter. Mr. Gorton, have you had an opportunity to read and review the pre-sentence report?
Yes, ma'am.
Have you had an opportunity to discuss the pre-sentence report with your attorney?
Yes, ma'am.
Are you satisfied with Mr. Malaro as your attorney and the advice that he has given you?
Yes, ma'am.
Mr. Malaro, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Judge, I guess it's my way of explanation. If the court recalls last week, we had an issue with respect to the guidelines. We adjourned it to today to get that ironed out. Mr. Sneed and I met, discussed that issue, and he sent an email yesterday outlining the discussion we had and the scoring of the guidelines. I don't know if that the court received that. I can give the court a copy, but I think it should be attached to the pre-sentence report, and we have no objection to the alteration, which would then put Mr. Gorton on count 1, 19 to 38 months.
So can we hold on one second? So in the PRVs, and Mr. Sneed, I'm sorry, I wasn't sure which one you were on. So Mr. Sneed is also appearing on this case. So one of the PRVs have been changed.
It was the OV judge, OV 12.
OV 12 is changed to,
It would be 5 points.
okay,
That'd be as to counts 1 and 3.
okay. I have count 1 and 3, okay. So both of them be scored at 5. Okay, and then OV12 scored at 5 on both of them. So does that on the weapons, firearms, possession by a prohibited person, the guidelines were 9 to 23, does that change those?
Yes, Judge, it would change the 9 to 23 to 12 to 24.
And you agree with that, Mr. Sneed?
I do, Your Honor. Thank you.
Oh, okay, and then on count 3, possession of methamphetamine, the guidelines were 10 to 23.
It would change to 19 to 38.
19 to 38. And you agree with that as well, Mr. Sneed?
I do. Thank you, Your Honor.
All right, excellent. We will make those changes and Mr. Stevenson, you'll get me an updated guidelines sheet. Okay. All right, so I've made that change. Did you wish to explain or challenge the accuracy or relevancy of anything else in the sex report?
I do not, Judge.
All right, what about you, Mr. Sneed?
No, thank you, Your Honor.
Okay, so before the court passes sentence, Mr. Sneed, is there anything you want to say on behalf of the people?
No, thank you.
Mr. Malaro, is there anything you want to say on behalf of Mr. Gorton?
I would, Judge, you know, as often is the case with a lot of these younger guys, their behavior's kind of baffling. They certainly seems affable when, while I've represented him. He understands he's, you know, really screwed up here. The only request I would have, Judge, that we did an agreement to 30 months. This matter was adjourned a week through no fault of Mr. Gorton. I would ask, and because he's on parole, he doesn't get credit, but I would ask the court to alter the 30-month sentence to reflect that 7 days. So 29 months and 21 days, whatever. That'd be my only request, because this was not anything he did. This was just something that had to be resolved.
Right, but he's doing dead time now anyway, right? Yeah,
Correct.
So, okay. I don't even know if we give MDOC sentences in weeks. I don't know, do we?
I've never
seen it.
Let's try it.
I know. Well, Mr. Sneed, your position.
I defer to the court's discretion, Your Honor.
Okay. All right. Can I do 20? Mr. Sneed, do you have an objection to 29 months? I can't do weeks. I can't do 29 months and 21 days to. Oh, he froze. Mr. Sneed.
No, I'm thinking. No, I don't have an objection.
Okay. All right. So thank you for making my lack of mathematical skills more comfortable on that one. All right. So then it would be on count one. He would, okay, so 29, 120. And then second one was 24. Okay. Okay. Mr. Gorton, is there anything you'd like to say on your own behalf?
No, ma'am.
Okay. All right. In determining, Miss Underwood, do you need to speak with Mr. Robinson?
Yes.
All right. So while I'm doing this, I am going to, hold on one second, put Miss Underwood and Mr. Robinson into a breakout room.
Thank you very much, Your Honor.
You're welcome. So Mr. Robinson, I'm going to open up a breakout room to give you a chance to speak with Miss Underwood. There you go. All right. So in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for law, and protection of society. Mr. Gorton, it is a sentence of this court that on file number 24-21934FH, you will serve 29 months to 120 months with the Michigan Department of Corrections. You get 0 credit, obviously, because you're on parole. This would be consecutive to the sentence you're currently serving on your parole. And there is $130 crime victim assessment fee and $68 in state costs. On count 2, it's a sentence to the court that you will serve 24 to 60 months with the Michigan Department of Corrections. You get 0 credit for time served. It runs concurrent with count 1, but again, consecutive to your term of parole at this time. And then there is a $68 state cost fee. Now, you do, Mr. Gorton, have a right to appeal this sentence, and we're going to send it over to you at the jail 3 copies of your notice of right to appellate review. 1 copy, they're going to ask you to initial and date, and that's for my records, just to acknowledge that you received the paperwork. The other copies are for you, and if you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. Thank you, Mr. Gorton.
Thank you, ma'am.
All right.
Thank you, Aaron.
All right, and Mr. Millar, if you want to go back there, I will put you in a breakout room with Mr. Perkins.
Thank you.
You're welcome. So Mr. Perkins, your attorney's going in back. And then hold on, Ms. Bloomhart, I will take you next.
Mr. Lyens is here.
And Miss Underwood's in. All right. Mr. Gorton, you're all set whenever.
I like to open the door.
Okay. I just didn't know if you thought you had to stay.
Yeah, no, I just
All right.
gotta open the door.
Okay, not a problem. All right, Mr. Glazier, I'm gonna call for your client. Hold on. Hi, this is Judge Anzalone again. I know I have like 3 jail windows open, but I'm ready for Cody Kuseno and then John Madison, Alyssa Smith, and Samantha Barrett. That order, and that order is fine. Yep,
Okay, so you want all like your 8:15s knocked out?
yep, from the bottom up.
Okay, got you.
All right, thank you.
You got it. Bye.
Bye. All right, so Mr. Murphy, let me find your client's file. Okay, that's Mr. Perkins. Where is Ms. Bloomhart? There. Oh, there we are. All right, Ms. Underwood, I'll bring MDOC back and I'll be right with you. And Ms. Underwood, Mr. Lyens is here. So Mr. Murphy, hold on, Ms. Robinson's coming back. Okay, so Mr. Malaro, I'm gonna put you in a breakout room with Mr. Perkins. And go ahead and join that breakout room. Okay, so we are back on the record in the matter of the people of the state of Michigan versus Lindsay Ray Bloomhart, file number 24-21978FH. This is the date and time set for sentencing. I'm Matthew Murphy appearing on behalf of Ms. Bloomhart. Not prosecutor anymore. So, Mr. Murphy, have you had an opportunity now to discuss the pre-sentence report with your client?
Yes, Your Honor. Thank you for that breakout session.
All right. So, Ms. Bloomhart, you've had an opportunity to read and review the pre-sentence report,
Yes, I have.
and you've had an opportunity to discuss that report with Mr. Murphy.
Yes,
All right. And are you satisfied with Mr. Murphy as your attorney and the advice that he has given you?
yes.
Mr. Murphy, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor.
All right, before the court, well, does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect? I do see she has moderate misdemeanor court history.
No, Your Honor.
All right, before the court passes sentence, is there anything you'd like to say on behalf of your client?
Your Honor, we're just asking the court to adopt the recommendation of probation in this matter. 12 months probation seems appropriate. We'd ask the court to consider reduced fines and costs spread out over those 12 months of probation. Ms. Bloomhart is not employed right now. Obviously, she'll pay what she can, but she'll just asking for the court to consider that. And she'll do community service to pay off what she can as well. But that's all she's asking the court to consider. Again, we'd ask the court to adopt the recommendation of probation in this matter.
All right, Ms. Bloomhart, is there anything you'd like to say on your own behalf?
No, I'm good. Thank you.
Are you currently employed? You're not currently employed, Ms. Bloomhart?
No, I'm in the middle of applying for Social Security. So,
Okay.
the Catholic Charities helping me.
Okay. All right, in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offenses, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. It's a sentence of the court that will be placed on probation for a period of 12 months. You are to continue and take medication as required through Catholic Charities for mental health concerns. I'm going to order that you pay $50 in state costs, $75 crime victim rate fee. There is a $30 per month supervision fee, and I'm going to assess $250 in court costs. You are to, as I said, continue your counseling and take your medication as prescribed, sign any releases of information for the probation department. You are not to engage in any assaultive behavior of any nature, physical or verbal, and you are not to have, let me go back here, have any contact with EH, and you are not to have any contact with AF, which were both the minors that were the victims in this matter. So
Okay.
no contact with them. Now, Ms. Bloomhart, we are going to mail to you 3 copies of your notice of right to appellate review. We're going to ask you to sign 1 copy where marked and mail it back to us in the self-addressed envelope that we provide for you. The other 2 copies are for you, and if you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. Do you understand that?
Yep.
And then next Thursday, I need you to report to district court probation and ask to speak with Mr. Mike McCarron, all right?
Okay.
And you do
And then-
that between 8 and 10 in the morning,
8 and 10. Okay.
okay? All right,
All right.
anything else, Mr. Murphy?
Nothing further, Your Honor. Thank you.
All right, well, I wish you the best of luck, Ms. Bloomhart.
Thank you.
All right, thank you.
Thank you, Ms. Bloomhart. You have a good day, okay? Contact
Thank
me if
you.
you have any issues, all right?
Okay. You too.
All right, Miss Underwood, I'm back to you. Where's Miss Underwood? Oh, how do you do that? All right, come on up to the podium. All right, have you had a chance to speak with Mr. Robinson?
Yes.
I was looking for you on my Zoom screen because that's where you were. All right, so this is in the matter of the people of the state of Michigan versus Michael Dwayne Robinson, file number 24-21698FH. I have Rhonda Underwood appearing on behalf of Mr. Robinson. Let me get the KSI. All right, Mr. Robinson, are you able to hear me?
Yes, ma'am.
All right, Mr. Robinson, you're kind of soft-spoken, so I'm going to need you to speak up loudly so that we get a good recording of it, okay?
Yeah.
Okay, thank you. So, Mr. Robinson, have you had an opportunity to read and review the pre-sentence report?
Yes.
Are you satisfied with Ms. Underwood as your attorney and the advice that she has given you?
Yes.
Ms. Underwood, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
We do not, Your Honor.
Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
It does not, Your Honor.
The probation department in this matter has computed the sentencing guidelines to be, hold on, let me get back there, is 5 to 17 months. Do you agree with that calculation of guidelines?
That's correct, Your Honor.
All right, and Ms. Underwood, there is a Cobb's agreement that he will be sentenced to the low end of the guidelines, and the court will honor that. Before the court passes sentence, is there anything you'd like to say on behalf of Mr. Robinson?
Your Honor, Mr. Robinson obviously
has mental issues that he's had since he was a child. And those are only exacerbated by his background and by where he finds himself. He understands that his conduct was inappropriate. He does. And when he's medicated properly and treated properly, I suspect these things don't happen. That being said, we thank the court for the Cobb's agreement in this manner. Mr. Robinson understands precisely what his sentence is going to be. And he understands that it's consecutive to what he's serving now. And we thank the court for honoring that today.
All right. Mr. Robinson, is there anything you'd like to say on your own behalf?
No, ma'am.
All right. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. Mr. Robinson, it's a sentence of the court that you will serve a period of 5 to 30 months with the Michigan Department of Corrections. You do not get any credit because you were an inmate at the time this offense occurred. So this will be consecutive to the sentence you're currently serving. There is a $130 crime victim rights fee and $68 in state costs. Now, you do have the right, Mr. Robinson, to appeal this sentence. We are going to get you 3 copies of your notice of right to appellate review. Initial and date 1 copy for our records, just to acknowledge you received it, and we'll get that back. The other 2 are for you, and if you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. Mr. Robinson, I wish you the best of luck, okay?
All right.
All right, thank you, Mr. Robinson.
Good luck, Mr. Robinson.
Do you want to take care of Mr. Lyens? Well, do you want Mr. Lyens brought down? Do you want Mr. Lyens brought down?
Lyens? I don't believe I have a.
Oh, Benjamin Lyens for
Lyens. I'm sorry. I have to speak with him, Your Honor.
All right, go ahead and talk to him and then we'll bring him down. All right?
Okay.
Okay, Mr. Malaro, you have Mr. Perkins.
Ready, Judge.
And then I got Mr. Madison. Oh, actually, Rhonda, are you ready on John Madison?
Yes.
Wait just a minute. Let's do him before you go down there.
Let me just get on my screen first.
Okay.
Your Honor.
Lyens is the lockup.
No, I wanted to do John Madison, so Mr. Madison can go on his way today. So let her talk to Mr. Madison first. All right, this is in the matter of the people of the state of Michigan versus Lesean Perkins, file number 24-21758FH. I have Salvatore Malaro appearing on behalf of Mr. Perkins. Mr. Perkins zoomed in today. So I do have a letter from Darren Coast dated April 9th of 2025 that states that Mr. Perkins continues to drug test at the pretrial services office in Battle Creek. He is only positive for THC on his test. He has presented with a medical marijuana card, and he has done well while out on bond. So, Mr. Perkins, have you had an opportunity to read and review the pre-sentence report?
Yes, ma'am.
So, Mr. Perkins, everybody's really quiet this morning, so you're very soft-spoken. So I'm going to need you, or maybe it's your microphone, but I'm going to need you to speak loud enough that we can make sure we're picking it up on our recording system. So you've had an opportunity to read and review the pre-sentence report?
Yes, ma'am.
Okay. Are you satisfied with your attorney, or you've had an opportunity to discuss that with Mr. Malaro?
Yes, ma'am.
Thank you.
Okay, there's a delay, so we'll recognize Mr. Perkins has a delay. So are you satisfied with Mr. Malaro as your attorney and the advice that he has given you?
Yes.
Do you wish Mr. Milaro to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor.
All right, does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect? I show he has 3 prior felonies, 13 prior misdemeanors.
Not to my knowledge, Judge.
All right. The probation department has computed the minimum sentencing guidelines to be 0 to 11 months. Do you agree with that computation of guidelines?
I have no objection to the computation.
All right, before the court passes sentence, is there anything you'd like to say on behalf of Mr. Perkins?
Judge, Mr. Perkins has always appeared in court as required. He's always maintained contact with me. He's a little old, but I think this whole incident's been a wake-up call to him. He has, I think, ready to lead a productive life, and we'd ask the court to follow the recommendation.
All right. Mr. Perkins, is there anything you'd like to say on your own behalf?
No, ma'am.
All right. Okay, in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. So, Mr. Perkins, obviously you do not live in our county, is that correct?
Yes.
Oh, okay. So I'm going to place you on probation for a period of 12 months. During that term of probation, let me look at suspended. Hold on one second, I'm looking at something. All right, during that term of probation, I'm not gonna order the alcohol provision because I don't see an alcohol history, but Mr. Perkins, during that term of probation, you are not to use any illegal controlled substances or be around people that have them. You must complete any outpatient or residential treatment if referred to by your probation officer, complete an assessment if required. You must submit to search of your person and property. That includes your house, your car, your phone, whatever, backpack, whatever, without a warrant, if the field agent has reasonable cause to believe that you have items which violate the conditions of your probation. We'll give you credit for 7 days in jail you've already served. There's a $130 crime victim assessment fee, $30 per month supervision fee, $750 in court costs, $68 state cost. I think that's it. Okay, now, Mr. Perkins, you are going to have to come here one time. Is that correct, Mr. Stevenson?
Correct.
And when do you want him to come?
This Tuesday, 9 a.m.
All right, do you work in the morning, Mr. Perkins?
Yes, ma'am.
What is your work schedule?
I work from 7 in the morning to 5.
Okay, so Mr. Perkins, you're gonna have to come here one time in person to report, to fill out the paperwork to transfer your probation. Will you be able to do that this Tuesday or you need about another week?
Yeah, I'll be able to do it.
You will? Great. So this coming Tuesday, I need you to report to the probation department by 10 a.m. Can we do 10 because he's in Battle Creek? By 10 in the morning. They'll do the paperwork to transfer your probation to where you currently live and set all that up. Now you do have the right to appeal the sentence. We're going to mail to you your notice of right to appellate review, and there'll be a self-addressed envelope. So one copy will be marked for you to initial and date. The other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. And Mr. Perkins, I wish you the best of luck.
Thank you, Lynn.
All right,
Lesean,
thank you, Mr.
Lesean, you're no longer required to test for me, so test under the direction of your PO.
Okay,
Thank you.
thank you.
Okay. Okay, all right, you're all set, Mr. Perkins. Okay, so,
Thank you, Judge.
thank you. Are you ready on Mr. Madison?
I am.
Okay, let me grab Mr. Madison's file. Okay, all right, this is in the matter of the people of the state of Michigan versus John Carl Lorenzen Madison. I think it's probably, is it Lorenzen or Lorenzo?
Lorenz.
Lorenz, thank you. Lorenz Madison, file number 23-21575FH and 23-21625FH. I run Underwood appearing on behalf of Mr. Madison. This is the date and time set for sentencing. Mr. Madison, you do have your father here in the courtroom to support you. So, Ms. Underwood, you had time to speak with Mr. Madison?
No, we've already spoken.
Okay, so Mr. Madison, have you had an opportunity to read and review the probation violation report?
Yes, I have.
Say that again, Mr. Madison.
Yes, I have.
Okay, good. Now, have you had an opportunity to discuss the report with your attorney?
Yes, I have.
Are you satisfied with Ms. Underwood as your attorney and the advice that she has given you?
Yes.
All right. Ms. Underwood, do you wish to explain or challenge the accuracy or relevancy of any information in this pre-sentence report?
The only thing we would say, and the only concern Mr. Madison had, was the time served on the jail, Your Honor. He believes that should be 200, I believe it's 201 on each file, not on just one of the files.
Okay, Mr. Moore, I show credit for 184 on docket number 23-21625 and 201 on 23-21575.
Yeah, I pulled all that off of the previous reports, sentencing dates, and credits. So, I mean, we can go back and look at it, but you'd have to give me a minute, but it should be accurate what I have.
Okay. All right, so we will look into that, Ms. Underwood, and correct it if we need to. All right.
Thank you.
All right. Anything else?
Nothing else as to accuracy.
I'm gonna get rid of MDOC. They're kind of, okay. All right. Anything else?
No.
Mr. Madison, anything you want to say on your own behalf?
No, ma'am.
No, is there anything you want to say on behalf of Mr. Madison?
Absolutely.
I thought you already did. I'm sorry.
No. Your Honor, Mr. Madison understands the report. He welcomes the opportunity to receive treatment. I believe there's a bed available for him. His family has expressed that to me. So I don't think he has to stay in jail very long at all to await a bed. We would ask for the minimum jail time involved to get Mr. Madison into treatment and back down the road.
Okay.
To better health.
All right, Mr. Madison, anything you want to say on your own behalf?
I just, my family said they had a bed waiting for me at Harbor Light. I just want to let you know that I'm willing to go there and do it all over again, start again.
Okay.
That's all.
All right. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the class of confinement, the sentencing guidelines, the report recommendation of the probation department, as well as what has been said upon the record in this matter. So, Mr. Madison, you do remain eligible for recovery court. I will tell you that it's been like a great honor to be a part of it. I'm not the most important part of the recovery court, but I have seen people I never thought in a million years could turn their life around, do it. So, I mean, you're getting older, you're more mature. I mean, it's time, Mr. Madison, to make those changes, and I'm glad that you are open to that. So, I'm gonna order that, that you will need to be assessed by community mental health and referred to inpatient treatment. I'm going to order that you remain and engage in the recovery court program. I'll reinstate your probation. I'll order 90 days in jail with credit for the 14 days served on your violation of probation. But as soon as we can get a bed for you, you'll be released, okay?
Okay.
And it sounds like there's a bed lined up. Mr. Madison, you gotta go to the program, you gotta complete it. If you don't complete it, if you leave, that's a violation of probation. You
Right.
understand?
Right. Yes, ma'am.
And, you know, you have an 8-year max on one of these, you could end up going to prison. So it's time, you know, your family's here to support you. There's a lot of people counting on you doing well. So, anything else, Mr. Moore, on the recommendation?
No, that's it, Your Honor.
Okay, and you do have the right to appeal this sentence, Mr. Madison, and we're going to send over to you a notice of right to appellate review. There'll be 3 copies for each file. I need you to sign and date 1 copy for our records that you received it, and the other copies are for you. And if you wish to appeal the sentence, you would fill out information on the form and mail it to the address listed on the form within 42 days. All right, Mr. Madison?
Yes, ma'am.
All right, I look forward to seeing when you get out of recovery or out of the inpatient program, all right?
Thank you.
Thank you. Bye, Mr. All right.
I'll go down and speak with Mr. Lyens.
Okay.
Guys, have a good day.
You too. All right, go ahead. And then tell them we're ready whenever you are. All right. All right, so I got Matt Murphy, I got John Glazier. Mr. Glazier, you ready for Mr. Kuseno?
Yes, Your Honor.
Okay, so this is in the matter of the people of the state of Michigan versus Cody Ryan Kuseno, file number 25-22104FH and 25-22151FH. I have John Glazier appearing on behalf of Mr. Kuseno. Ms. Holly is present in the courtroom. So this is the date and time set for sentencing. Mr. Kuseno, have you had an opportunity to read and review the pre-sentence report?
Yes.
Are you satisfied with Ms. Underwood as your attorney and, no, I'm sorry, Mr. Glazier as your attorney and the advice that he has given you?
Yes, Your Honor.
No, the civil case. All right, I know the civil case they said settled. All right, Mr. Glazier, do you wish to explain or challenge? Wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor.
Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
No, Your Honor.
The probation department has computed the minimum sentencing guidelines on count 1, possession of cocaine less than 25 grams to be 0 to 17, and count, and that's on file number 25-22104, and then on 25-22151FH to be 5 to 23 months. Do you agree with that computation of guidelines?
Yes, I do, Your Honor.
So he's not gonna be available.
You don't know why I got transferred to second. I'm making transfer to second all that stuff.
All right, Miss Adams, hold on, Mr. Glazier. Mr. Adams, Miss Adams. Are you there?
Yes, on Rutherford, if that's what you're talking about, I forwarded you an email. We don't know where he's transferred to at this time.
Well, he got transferred to Saginaw.
Oh, okay.
Yeah, come on up to, we're gonna pause for a minute, Mr. Glazier. So we have a 9:30 in the matter of the people of the state of Michigan versus Jerry Lee Rutherford, the third, file number 21-20509FH. It was date and time set for a bench warrant. Can you state your name and P number, please?
Yes, Kevin Cousins, P85044.
Okay. And you've been informed he's been transferred where?
His mother just called me 15 minutes ago and said he was transferred to Saginaw. Now, I'm assuming that's Saginaw County Jail. She could not give me any more information than that. I'm not, we did know he was in Midland up until yesterday. I have no idea why he's been transferred.
Do you want us to set this out like a couple weeks and try to zoom him in?
Yes, please.
All right, Ms. Adams, could I get another date a couple weeks out to try to Zoom Mr. Relaford in?
Okay.
Some counties are very, work with us really well, some don't, so depends on their technology.
April 24th at 8:15.
April 24 at 8:15, Mr. President?
That's fine, Your Honor. Thank you.
All right, and Ms. Adams, can we do the notice of hearing then? I think we
Yes.
do on that anyway. All right, and then we will try to get them zoomed in from Saginaw.
Great. Thank you, Your Honor.
All right, if you get any information specifically where he's at, if you can let my staff know, that'd be great.
I'd be happy to.
Okay, thank you.
My Vine Lake told me last night as well, Saginaw County Jail.
All right, so Ms. Adams, Ms. Holly said he's at the Saginaw County Jail.
Okay, thank you.
Thank you, Ms. Holly. All right, sorry, Mr. Glazier, we're back with you. I don't know where I was. I did the guidelines. Okay, so before the court passes sentence, you had agreed to the guidelines. So is there anything you'd like to say on behalf of Mr. Kuseno?
Your Honor, he has another file where he's due to be sentenced on May 16th, I believe. The only request I'd make is I think on one file it was 180 days and then can be released. And on the other file, it was just sentencing him to whatever time he served. I'd ask that one be 180 days to be released as well, so it'll get credit on both these files, at least until May 16th.
So what my brain broke. What did you just ask?
Maybe I've read it wrong, but there's two files here. On one file, the recommendation is 180 days.
Yes, sir.
To be released to a program. The other one is not. It says just give him credit for time served. Well,
Right.
we know he's going to be there at least till May 16th because he has that sentencing coming up. So I'd ask the other one where it says just credit time served be 180 days to be released to a program, just like the first file.
Okay. Is he being sentenced and made by me?
Yes. Yes.
Do you want me to set these together?
I guess that would do the same thing, Your Honor.
Okay, so, and what day is that sentencing?
I think it's May 16th, I believe.
It's May 16th.
So I'm gonna set this over to May 16th at 8:15 in the morning, Mr. Kuseno, just so we know that everything kind of goes together and that you get appropriate credit on everything and tie it all together, all right?
Okay,
All right, thank you, Mr. Kuseno.
thank you.
Okay. Mr. Lyens, wanna go up to the podium?
Yes, ma'am.
All right. Thanks, Ms. Howard. All right, this is in the matter of the people of the state of Michigan versus Benjamin Lyens. And this is file numbers 23-21610 FH, 23-21611 FH, and 24-21736 FH. This is the date, time set for violation of probation sentencing on all these files. Mr. Lyens is present in person and represented by Ms. Underwood. So, Mr. Lyens, have you had a chance to discuss the pre-sentence report with your attorney?
Yes, ma'am.
Are you satisfied with Ms. Underwood as your attorney and the advice that she's given you?
Yes, Your Honor, very much so.
All right. Ms. Underwood, do you wish to explain or challenge the accuracy or relevancy of any information in this report?
There was one thing Mr. Lyens had a question about, and that's on the first page, docket number 23216 FH, 21611 FH. He believes that was only one count of controlled substance possession, Your Honor. And it's
21611. Okay, hold on. Let me get it. Okay, hold on. 216. One. All right, it looks like, let's see. We're following probation, contempt, and Miss Adams' little sheet. Order of probation. I do show he only pled to 1 count, so I think it's just a typo.
Thank you.
Yeah, so I do show that he only pled to 1 count on that one. So I think it just regenerated it or something.
Correct.
All right. Okay. All right, so. Anything else, Miss Ann or Miss Underwood?
Nothing as to accuracy and relevancy, Your Honor.
Okay. Is there anything you'd like to say on behalf of your client before the court passes sentence?
My client really understands the seriousness of the issue here, Your Honor, and he is very willing to address it in any way the court feels appropriate. One thing he would ask, he understands the recommendation for the jail term, Your Honor, but Mr. Lyens has 7 children, I believe, and he would very much like to be home with them on Palm Sunday if he can be. We would ask the court to consider that in determining whether or not the 15 days is a full 15 days, Your Honor. And with that, I don't know if Mr. Lyens has anything he would like to say.
Okay.
Your Honor, can I add something?
Sure. I was just Googling what Palm Sunday was, but okay.
Okay. So with Mr. Lyens, he didn't, the team feels he probably could use an inpatient program. If I wanted to, I could have recommended up to 45 days jail with them, assess them for
Didn't he
treatment.
complete Salvation Army?
Just a detox, just a short detox.
Okay.
And then he wasn't prior, but what I want to say is, yeah, he wasn't interested in going off to treatment at this point, so I granted him that we can always visit this again. But that, the jail term is pretty short, and I would recommend that he serve it.
Okay.
And one thing I would like to express, I'm sorry, Your Honor, is that Mr. Lyens has a medical condition where sleeping flat is very, you can't breathe.
I took an ambulance ride from Harbor Lake. I fell down and when I was detoxing or whatever, my blood pressure was 165/60 from alcohol. And so anyways, it doesn't close, my stomach doesn't close off from my esophagus when I'm sleeping. So while I'm in jail, they won't address the issue, but I've had it happen twice. Since my blood pressure has been lower, I've been able to get up and vomit or whatever I need to do. But it is, I'm a liability in the jail because they won't take into consideration that I have to be elevated in order when I sleep, or else I can aspirate and die. So I had a head injury that they took me by ambulance from Harbor Lake to the hospital in the middle of the night, and so that's a big issue.
Okay. I'll tell you, if the jail thinks you're a liability, I will get a call 24/7 about that because they want people out if they're considered a liability. All right. Is there anything else, Ms. Underwood?
Nothing else, Your Honor.
Anything else, Mr. Lyens?
Your Honor, with all due respect for, time where I admired a man, he was my parole officer 20 years ago, be successful, for 12 years after I was I understand that, not to undermine him by any means. I did get the Vivitrol shot, which means too much drinking, at this point, the humility factor of me messing up and just me being down on myself for it, because, I was all about the program, 2 or 3 meetings a day, above and beyond everything, I would love to get back to that, if you were to allow me out to observe, Palm Sunday with my children and everything like that, meetings and everything. And I just want to get back to, even during, during my drinking, I started drinking again, I sobered up for like half a day, and went to a Pathways meeting like was accustomed going to. I bawled my eyes out the whole time. I walked there, I was a little bit late, and I ran, but I talked to people. I just couldn't get the energy up to get to detox. And finally, I got the motivation to do so, and I got there and I did it. And I spent 6 days that said I'm like detox. So this was asking maybe like some of that could be. I know 15 days is very generous, but if some of that could be considered into.
So, Mr. Likens, what I'm starting to see in our recovery court program is when I release people on a Friday, they relapse. I'm just seeing it all the time now, and I think Rachel would agree. We're seeing a lot of that. So I appreciate everything you're saying, and obviously Palm Sunday, depending on the church you attend, is important, but these are the ramifications, and I'm not comfortable releasing you today. All right, it's sent to the court that your probation will be continued. You are to remain in the Lenawee County Recovery Court program. Typically you would be going to a rehab program right now. Yes. So Mr. Moore really is giving you a break. So you need to understand that. And like, you turned yourself in, which is amazing. You completed this detox program. You took a Vivitrol shot. I'm super proud of that. But in light of the fact that you're not going to recover, I have a problem releasing you on a Friday. So what I am going to allow you to be released from the Lenawee County Jail on Tuesday. Okay. And that's our recovery court report date, right, Rachel? I think, yeah. So that'll get you right in with Sarah, and we can get services in place so we don't have to worry about a relapse again. And, and hopefully you'll never miss another Palm Sunday, but you'll be there for Easter, right? And so I will allow for you to be released, as I said, on Tuesday, April 15th. That'll really shake midnight or something like that, I think.
That'd be awesome. Thank you.
Okay, but Mr. Likens, next time there's a relapse, you're probably going to rehab, all right?
Understood.
Okay. All right, and Mr. Likens, you do have a right to appeal this sentence, and my bailiff's going to hand down to your notice of right to appellate review. You're going to initial and date one copy just for our records for each file. Is that on each file, Mr. Moore, or just that sentence? Do we just do this on, let me see.
No, on each file.
On each file? Okay.
As far as the
So,
credit.
okay, and you've got credit for 7 days now, and like I said, we'll release you on that day, and that'll be for each file. So you're gonna have to date initial 3 copies of your notice of right to appellate review, 1 for each file. 2 files. Is there only 2 files? 2 files. And then the other copies are for you. And if you wish to appeal the sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. There's not 3 of them?
No, I only have 2.
All right. Do you have file number 610 at the end?
No.
611?
611 and 736.
All right, Miss Adams, I need appellate paperwork on file number 23-21610, please.
Okay.
All right, we'll get that appellate paperwork.
Your Honor, do we have Mr. Norman?
Yeah, I'm making him watch. Mr. Norman's had to watch my docket this morning. All right. Let's see, where did my Robinson? I do have Samantha Barrett and Alyssa Smith. All right, so Mr. Likens, I just, Palm Sunday took me back to when I was a little girl at my church. Okay, so do good. All right. All right, I'll see you back next week. All right, thank you.
Last weekend.
Yep, you too. All right, Alyssa Smith and Samantha. Have you met with both of them, Miss Underwood? Have you talked to Miss Barrett and Miss Smith?
I have not talked to Miss Barrett. I apologize. That came in late yesterday.
Did you talk to Miss Smith?
Yeah.
Okay. So in the matter of people of the state of Michigan versus Alyssa Smith, file number 20-20105FH. This is a date and time set for sentencing in this matter on a violation of probation. I have Rhonda Underwood present on behalf of Ms. Smith. And Ms. Smith, have you had an opportunity to read and review the pre-sentence report?
Yes, ma'am.
All right, have you had an opportunity to discuss that with your attorney?
Yes, ma'am.
Are you satisfied with Ms. Underwood as your attorney and the advice that she has given you?
Yes, ma'am.
Right, Ms. Underwood, as I said, this is a violation of probation sentencing. Do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
I don't believe we did.
Okay, before the court passes sentence, is there anything you'd like to say on behalf of Ms. Smith?
Just this, Your Honor. First of all, Ms. Smith welcomes the recommendation. She understands it. She's very sorry for her conduct. We were hoping the court might consider something less than the 90 days. That is.
She's recommending 45.
I'm sorry?
The recommendation is 45.
Right.
Yep.
There you go.
I apologize. She was hoping that the court might consider a lesser jail term on this, Your Honor.
Well, this allows for her to be released to treatment.
And we hope that won't take too long. Then I don't believe we have anything else unless Ms. Smith has something.
All right. Ms. Smith, is there anything you'd like to say on your own behalf?
No, I'm very pleased with the recommendation. And I appreciate everything that you guys did.
All right. So you do have the right. All right. So I guess sentence of the court will be that you will serve 45 days in Lenawee County Jail. We'll give you credit for 14 days. You can be released to attend residential treatment as soon as the bed's available. Shouldn't take that long. You will be continued on probation. You will be continued in the recovery court program. Ms. Smith, you know, you've had a lot of bad things happen. And maybe addiction was part of your way to deal with those issues. I don't know, but you're pregnant. So while I do criminal law cases and do cases of that nature, I also do abuse and neglect cases where I take babies away from moms who abuse drugs. Do you understand that? And you deserve better, your baby deserves better, but understand if I think you're using while you're pregnant, I'm gonna put you where I know you're safe, okay?
Yeah.
Okay, so, all right, and is there this individual, Mr. Moore, should there be a no contact with this individual? You're muted, Mr. Moore. Yep.
That would be a good idea.
And do we know his initials?
Yes. And I believe there is possibly one other person, but the initials I have, let's see. Give me a second. WH.
So ma'am, one thing I will say is I'm also not going to let anybody abuse you. All right. And then we are able to help you to find a place to live. We're able to help you to find treatment services for your pregnancy, but I also will not stand for abuse. Okay. So I will not stand, and you shouldn't either, to allow anyone to abuse you, no matter, you know, who he is. So I'm going to put a no contact in place with WH. Now, you do have the right to appeal this sentence. They're going to give you your notice of right to appellate review. Initial date, one copy for our, what, Mr. Moore?
There's one other individual with the initials LB, what I'd like to add on there for no contact, and I can create that too.
Okay, we'll add that individual too, because we want to keep you safe and we want to keep you healthy and in a good place. Sometimes Just because you may think you love somebody does not mean they're good for you. Sometimes love can be bad for you, right? And you deserve better than that. So you do have the right to appeal this sentence. We're gonna get to you at the jail 3 copies of your notice of right to appellate review. Initial and date, 1 copy are for our records, the other copies are for you. If you wish to appeal the sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. Ms. Smith, at this time with the recovery court, you have a team of people who are working to make sure you have a good, healthy life. Just embrace it. Let us help you. All right? All right. Thank you, Ms. Smith. You're all set.
Good luck, Alyssa.
Okay. Do you want to take care of Miss Barrett and then I can go off live stream? So you need to go zoom in. You're gonna go zoom in?
Yep.
Okay, go zoom in. All right. And Mr. Murphy, you're just staying on for the trial, right? Hi, Rachel.
I'm sorry. Yes, Your Honor. I'm just gonna wait and observe. That's okay.
Okay. I just was making sure I didn't miss you on something.
No, Your Honor. Sorry, I didn't mean to cause you any anxiety. No, there's nothing else that I had.
Mr. Murphy never caused me to have anxiety. There are things that cause anxiety, but you're not one of them. And thank you, Mr. Murphy. Now I have that song stuck in my head.
Oh, I'm sorry.
Maybe Miss Walsh and I can do a TikTok to the song. It's my anxiety. Miss Walsh is like, no.
Are you sorry, Mr. Murphy?
Yes.
All right, now I got Miss Underwood, Miss Barrett. I'm gonna give you a breakout room with Miss Underwood for a quick minute. She'll review the recommendation with you, and I have a trial, Miss Underwood, don't forget. Thanks.
I keep getting booted out, so just in case I do, it keeps refreshing and coming back, so.
Okay, that's because you live in that time warp area where service is bad.
It's usually not.
Really?
I don't know. It's weird.
All right, let me, no. I thought we were just gonna- I have a bench trial today. Is that gonna be you I call on that? Criminal
I
trial?
won't be here.
What do you mean you won't be here? You can't leave.
Yeah, no one's ever here. I'm not sure if I will be here.
So, Ms. Walsh or Mr. Moore, I have a bench trial today on a criminal matter. So who do I call if there's a conviction?
That would be me.
Oh, Jen said I'm supposed to call Mr. Moore.
Yeah, that's right.
Either way, what time is your bench trial?
Starts at 10.
Okay. It's gonna be over, huh?
I told her to call me.
Okay.
She's clever.
Uh-huh.
She chatted that to me. She's like, no, call time.
I'm sure she did. Okay, well, who's the defense attorney in the case?
Who? Oh, Mr. Rockett, he's a new attorney. And then Mr. Murphy is third chairing from Zoom. And I think Mr. Malau is second chairing on that one. And, yeah.
Got a team. Okay.
I got a team, yeah. We don't often do criminal bench trials, so.
Yeah.
What is it on for?
It's an hour now.
Oh.
So.
All righty. I think I'm all done here though, so I'm gonna get busy on these referrals.
Okay, well, thank you,
All
Mr.
right.
Moore.
Yep, have
I'll
a
call
good
you.
weekend.
I'll call you in a couple hours if I get a conviction.
Okay. Bye.
Bye.
Oh, that's funny. Oh, boy.
All right, I'm gonna take some of these files, Becky. There's like 300 here. I know, who wants to work on these?
It usually happens. One goes out, one comes in.
Easy.
Yeah. Busy for you.
All right, so we are back on the record with Miss Barrett. Ms. Barrett, have you had an opportunity to discuss the pre-sentence report with your attorney?
Yes, ma'am.
Okay, are you satisfied with Ms. Underwood as your attorney and the advice that she has given you?
Yes, ma'am.
Ms. Underwood, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
We do not.
Before the court passes sentence, is there anything you'd like to say on behalf of your client?
Ms. Barrett understands the opportunity she was given to do probation in this matter. I understand the time served is how long, Your Honor? Ms. Barrett claims it's like 30 some days.
So Ms. Barrett has a total amount of 129 days credit. They're recommending she serve 60 days with only 9 days credit. So whether I can say I can say they just, the recommendation is the 60 days with the 9 days credit. So that she'll do that on top of her credit for time served. So it's not a year. She's not getting a year in jail, which
she understands that.
Yeah.
She understands that. She just thought her calculation was different than that.
Because she was arrested on April 2nd.
And Ms. Barrett, see, you only, unless you're getting max year time, you only get credit for the violation that you're in on.
Okay.
Okay?
Okay.
Your Honor, Ms. Barrett understands. And I think Ms. Barrett desires really to address this problem and to tackle it. But it's probably going to be outside the purview of probation.
Ms. Barrett, anything you want to say?
I would like to say you've been really patient with me, and I know that I'm going to start crying, but my problem is, like, I don't give things a chance before I give up on them. And I do want to say that I did put myself in Harbor Light and go through the detox program on my own because I was drinking too much. I admit to that. And I did call Miss Walsh. I know that I had already been on the run for a month or so, but I did call her and let her know that I did go into a detox program so that I didn't have to come into the jail. I was coming to turn myself in, but unfortunately an altercation happened the night before when I was with somebody, and I literally just walked up to the police car and was like, here I am, because I can't do it anymore, like, you know. And so I do want to say that I did go to Harbor Light on my own and do the detox program, because I do not have no desire to drink or use drugs anymore, because it's not fun anymore. And I understand I won't be under the guidelines of probation, but like I'm telling you, I do not want to go down that road. I still want to be able to attend pathways and stuff like that if I'm allowed to. I don't know if I'm allowed to just go on my own or not, but.
You know, and Ms. Barrett, you know, there are so many services in our community to help you. And you know most of them because, you know, we've offered them to you. But, you know, CMH, you know, any number of services, the jail, I believe they can offer Vivitrol shots before you leave and point you in the direction. We have these wonderful programs now in our county where at the Sheriff's Department or at APD, if you walk in and you say, you know, I'm in the throes of addiction and I need help, they help you find beds, they help you find treatment programs. So these services, you know, the county recognizes and offers those services. So you know where to start. You dealt with a lot of them. So, you know, just keep working at it. And I hope you do. I hope you do. I wish you the best of luck. So, but you know, if it gets bad, if you show up here and you ask for help, we will find services for you. All right.
Okay.
All right. So it's a sentence of the court that you will serve 90 days. What it was.
I believe it's 60.
I'm looking, hold on. 60 days in Lenawee County Jail on this probation violation. We'll give you credit for the 9 days you've served on this probation violation, and we will revoke and terminate your probation. But as I said, Ms. Barrett, there are so many places you can get help in the county, and worst case scenario, you can always walk in the courtroom and ask for some guidance. So I wish you the best of luck. and I said we're revoking terminate probation, you do have the right to appeal the sentence. So we're gonna get over to you at the jail, your notice of right to appellate review. And then you'll initial and date one copy for our records, the other copies are for you. If you wish to appeal the sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. All right, Ms. Barrett?
All right, thank you. And thank you, Ms. Walsh.
Miss Barrett, we're not giving up. I'm not giving up on you. I just can't help you when you don't accept the help, and I just can't supervise you, that's all.
All right, I have one more weird question. I don't have any other charges, right, pending, like, because I didn't do anything. Like, I know I got caught, like, before I was able to turn myself in, but I just want to make sure I don't have any other pending charges.
I don't know. The jail would know that before you leave.
Okay.
Not that I'm aware of, but that doesn't mean anything, okay?
Okay.
All right, thank you. All
right, thank you.
All right,